benefit of compensation that they are entitled to and would have received, but for their premature deaths, which premature death was caused by the acts or unlawful omissions of the mining companies. For this reason, the common law has to be developed so that they are allowed to transit their claims to their estates upon their deaths. The argument bears considerable force. We examine the question whether the development of the common law should be left to be dealt with by the trial court in due course. The mine workers contend that this court should determine the issue now. One of the mining companies, African Rainbow Minerals, maintains that the issue should be left to the trial court, as that court will receive more evidence and therefore will be able to make a more informed decision on the matter than this court. We disagree with African Rainbow Minerals. All the facts that are pertinent to the determination of this issue are already known and placed before this court. The key facts are these. 1, the stage when litis contestatio will be reached, in this case, if indeed it will be reached, is very long way off. 2, the mining companies agree that a large number of the mine workers have already lost their lives as a result of contracting silicosis or TB, and that the only new evidence that the trial court will receive on this issue is that many more would have died before the stage of litis contestatio is reached. The new evidence will not alter the outcome of the issue. The death of a single mine worker with a legitimate claim is sufficient evidence for this court to note the undue, unjustified, and irreparable prejudice that will ensue if the issue is left undeveloped. 3, the common law in its present form endorses the financial loss and social harm that the estates of the deceased mine workers and their families endure as a result of these mine workers succumbing to the diseases of silicosis or pulmonary TB. The mining companies are the only ones which benefit from this state of affairs, and their benefit is at the expense of the deceased mine workers and their dependents. 4, it is common cause that the law does not reflect the legal convictions of the community and violates a number of constitutional principles, some of which we have referred to, and to that extent, it fails to promote the spirit, purport, and objects of the Bill of Rights. And 5, finally, the issue has been extensively canvassed in the pleadings before this court and comprehensively argued by the parties. There is no doubt that the facts of this case, on the face of this, a huge injustice would result if the general damages that would have been due to the now deceased class member is denied simply because he succumbed to his disease before the case he brings or intended to bring had reached the stage of litis contestatio. The injustice is all the more poignant when regard is taken of the fact that a denial of the benefits of general damages to the beneficiaries of the estate of the deceased class member could well result in the mining companies securing a benefit from the very harm they caused the deceased class member. Undoubtedly, the loss of general damages by dint of operation of the existing common law will in this case be borne by the widows and the children of the deceased last member, as they would have benefited should their primary provider not have died pre-litis contestatio. It bears reminding that they are the indigent, the weak, and the vulnerable in our society. That they should bear this loss and the respective mining companies benefit from the death of their spouse and or parent is grossly unjust, especially when regard is taken of two facts. One, the respective mining company's conduct or wrongful omission may be a significant contributor to the early death of their breadwinner. And two, the respective mining company's attitude and approach to the litigation has a significant influence over when the stage of litis contestatio is reached. In fact, to the extent that they can amend their pleadings at any time before judgment is given by the trial court, they have significant, if not determinative, control over when the stage of litis contestatio is reached. Consequently, if the law is not developed, then in this case, it would have failed the weak individuals and benefited the powerful corporates. It has to be borne in mind that while the mine worker experienced pain and suffering from the loss of amenities of life prior to his death, his widow and children too bore some hardship by virtue of the care they were required to give to him as a result of his loss of amenities of life. In the light of these circumstances, and bearing in mind the injunctions of subsections 8.3 and 39.2 of the Constitution, it is our view that the common law has to be developed to allow the claim for the general damages to be transmissible to the estate or executor of a deceased mine worker, even though the stage of litis contestatio had not been reached at the time of his death. Also, the development is necessary in the light of the court's general duty to do justice by the person affected by its orders. By holding that the common law can only be developed in the manner we suggest below does not, in our view, mean that we have ignored the judicial caution captured in the dictum that judges should only develop the common law incrementally. Judicial caution in this regard, it has to be remembered, is born out of a need to ensure that the judicial arm of the state does not trespass on the field reserved for the legislature. Legislature is doubtlessly better placed to make laws than the judiciary. But as we point out above, judges are often required to make law for no reason other than to ensure that the law adapts to the new circumstances and meets new challenges. This, we believe, is all we are doing. Moreover, the need for judicial restraint expressed in the dictum does not mean that we must always only develop the law piecemeal. How the law is developed depends on the circumstances that prevail at the time. Of course, if it is possible to make a small adjustment to the law in order to make it reflect the spirit, purport, and objects of the Constitution, then this must be the route to follow. But if by doing so, we create as many problems as we attempt to solve, or to put it differently, we create as much hardship and injustice as there already prevails in law, then small or piecemeal adjustment is to be avoided. The approach we advocate is not an innovation of ours. It has long been part of our law. More than a century ago, eNCA said, quote, "And we should be slow to perpetuate a form of legal remedy which may work hardship if it can be modified so as to do away with the possibility," close quote. We hold the view that this is precisely what will occur if we are to develop the common law on transmissibility of general damages only for class action suits. We have no doubt that the problems we allude to in this judgment and in previous paragraphs are bound to surface in practice. The only way justice can prevail in the cases of the individual mine workers or their dependents is if they are afforded an opportunity to pursue their claims by at least having significant parts of it determined through class action. Further, in our judgment, it is in the interest of the mining companies that the many common issues, as well as the common evidence referred to above, be dealt with in at-large proceedings. As for the practical arrangements, we hold that these can be fully and finally determined by the trial court after pleadings have closed and all the factual and legal issues have been crystallized or been identified. It is not within the power of this court to prescribe to the trial court how it should structure its hearings. Accordingly, we reject the submissions of mining companies that last action is untenable and unmanageable, and hold to the contrary. We wish to reiterate that by holding that it is in the interest of that justice that last action be certified in this case, we do not, as was contended by the mining companies, hold that the mining companies are jointly liable for the harm suffered by an individual mine worker. Our law of delict is clear in this regard. A defendant can only be liable for his own delict and not for that of another defendant. The liability of each mining company will be determined at the second stage of the proceedings when all the mine workers and all the dependents of the deceased mine workers have staked their claims. At that stage, the claims will be paired against the respective mining companies alleged to have committed the delict. Hence, each mining company will be held liable or responsible for its own actions or unlawful omissions. But this does not affect the fact that a substantial body of evidence to be led against them is the same or common to all of them, and that the evidence is relevant to the individual mine worker's case. Once this is received, the common factual and legal issues are determined. The case, if necessary, will proceed to the next stage where the individual culpabilities will be scrutinized and determined. On the question of costs, the mine workers seek costs against the mining company, including costs of 9 counsel. They have assured the court that the services by counsel were shared and there was no duplication. The costs will follow that pattern. They assured the court that the combined costs of 9 counsel shall not exceed the cost of 3 counsel. This we find is justified, having regard to the complexity of the case and the aggregated strength of opposition by the mining companies. Counsel for the mining companies, like those for the mine workers, shared responsibility and topics in presenting the case to this court and would, if successful, all have been included in the mining company's entitlement to costs. The cost orders sought by the mine workers is, in our judgment, justified. For the aforesaid reasons, and for reasons more fully stated in the written judgment which we shall hand down, the court makes the following order. One, it is declared that the following persons constitute at-large. 1.1, current and former underground mine workers who have contracted silicosis and the dependents of underground mine workers who died of silicosis, whether or not accompanied by any other disease. 1.1.1, where such mine workers work or have worked on one or more of the gold mines listed in Annexure A to this order after 12 March 1965. 1.1.2, whose claims are not among the claims which by agreement are to be determined by arbitration in the matter of Blom and others versus Anglo-American South Africa Limited. And 1.1.3, who are not named plaintiffs in the action instituted in the United Kingdom against the Anglo-American South Africa Limited under case number HQ 11X 03245, number HQ 11X 03246, case number HQ 12X 02667, and HQ 12X 05544. The silicosis class. It is declared that the following group of persons constitute at-large. 2.1, current and former underground mine workers who have contracted pulmonary tuberculosis and the dependents of deceased underground mine workers who died of pulmonary tuberculosis, but excluding silicotuberculosis, where such mine workers work or have worked for at least 2 years on one or more of the gold mines listed in Annexure A after 12 March 1965, the TB class. 3, the attorneys of record for the applicants are certified as the legal representatives of members of the classes for the further conduct of the class action as follows. 3.1, Abrams Kiewitz Incorporated, Richard Spoor Incorporated, attorneys and the Legal Resources Center are certified as the joint legal representative of the members of the silicosis class. 3.2, Abrams is certified as the legal representative of members of the pulmonary TB class. And 3.3, the fee arrangements set out in Annexure RS 13 and RS 21 to the replying affidavit of Richard Spoor are authorized in respect of the legal representative of the classes. 4, in the further conduct of these proceedings, the following applicants, whomever are surviving at the time of the class action, are granted leave to act as class representative. 4.1, the first to 52nd applicants are granted leave to act as representatives of the silicosis class, of which they are members. 4.2, the 33rd, 35th, 36th, and 53rd to 69th applicants are granted leave to act as representative of the pulmonary tuberculosis class of which they are members. 5. It is declared that the class representatives in 4 above have the requisite standing to bring the class action and to represent members of the silicosis class and the TB class in claims for damages. 6. It is directed that the following steps shall be taken to give notice of the class action to members of the classes substantially in accordance with the notices attached as Annexure B1. 6.1. The applicant's legal representative shall forthwith publish the notice 6.1.1 as an advertisement in the newspapers listed in Annexure D hereto. The notice shall be published in each such newspaper once per week for a period of 4 weeks. 6.1.2. As a radio announcement substantially in the form of Annexure C1, broadcast on each of the radio stations listed in Annexure D and in the languages stipulated therein. Such broadcasts are to be made twice daily on alternative days for a period of 4 weeks. 6.1.3. On a prominent notice board at each of the offices of the applicant's legal representative for a period of not less than 180 days. 6.1.4. On a prominent notice board at each of the Employment Bureau of Africa in Southern Africa for a period of not less than 180 days. 6.1.5. On a prominent notice board at each Justice Center and Public Office of the Legal Aid of South Africa for a period of not less than 180 days. 6.1.6. On a prominent notice board at each regional office of the National Union of Mine Workers and the Association of Mine Workers and the Construction Union for a period of not less than 180 days. 6.1.7. By procuring Legal Aid South Africa to circulate the notice to each of its attorneys and candidate attorneys employed in providing legal aid in civil matters. 6.1.8. By delivering a copy of the notice to each advice office, paralegal office, and community-based organization with which the applicant's legal representatives are familiar and which are likely, in the opinion of the applicant's legal representatives, to be approached by members of the class. And 6.1.9. On the websites of the applicant's legal representatives. 6.2. The respondents shall publish the notice 6.2.1 on a prominent notice board for the mine workers at each mine owned, operated, controlled, and/or advised by the respondents for a period of not less than 180 days. And 6.2.2 on the homepage of each of the respondents' websites for a period of not less than 180 days. 7. The applicant's legal representatives are directed to file reports with the court on a quarterly basis, setting out the steps taken to publish the notice and the progress made in identifying the members of the classes. The first such report to be filed 3 months after the date of this order. 8. It is declared that any claimant who has claimed for general damages and who has died or dies prior to the finalization of his case will have such general damages transmissible to his estate, regardless of whether he has joined the class action or not. The claim of general damages in this case shall be transmissible from the date when the certification application was launched in August 2012. 9. It is ordered that members of the classes will be bound by the judgment or judgments in the first stage of the class action against the mining companies unless they give written notice to Abrams, Spoor, or LRC by 31st January 2017 that they wish to be excluded as members of any of the classes against each or any of the respondents. 10. It is ordered that 10.1, upon conclusion of the first stage of the class action, the members of the silicosis class must give written notice to Abrams, Spoor, or LRC by a date to be determined by the court at that time. 10.1.1, that they wish to opt in and be included as members of the silicosis class in the second stage of the class action. And 10.1.2, which respondents or respondents they seek to hold liable in the second stage of the class action. 10.2, upon conclusion of the first stage of the class action, the members of the pulmonary tuberculosis class must give written notice to Abrams by a date to be determined by the court at that time. 10.2.1, that they wish to opt in and be included as members of the TB class in the second stage of the class action. And 10.2.2, which respondent or respondents they seek to hold liable in the second stage of the class action. 10.3, only members who give such notice timeously will have the benefit of and be bound by the judgments in the second stage of the class action as against the respondent or respondents that are found to be liable to them. 11, the reference to respondent or respondents, 11.1 in paragraph 6.2 exclude the 20th, 21st, 25th, and 26th respondents insofar as they pertain to the notice obligation and cost in respect of tuberculosis class. 11.2 in paragraph 6.2 exclude the 20th and 21st respondents insofar as they pertain to the notice obligations and costs in respect of the silicosis class. 11.3 in paragraph 13 below exclude the 20th, 21st, 29th respondents as a whole and the 25th and 26th respondents insofar as they pertain to costs of the tuberculosis class. 12. It is ordered that the respondents are jointly and severally liable for half of the mine workers' costs of publishing the notices set out in paragraph 6.1 above. 13. It is ordered that any settlement agreement reached by the parties shall only be of force and take effect if approved by this court. 14. The conditional counterclaim of the first, second, fourth to eighth, and 32nd respondents is dismissed with costs. 15. It is ordered that the respondents are jointly and severally liable for the costs of this application, which costs are to include those occasioned by the employment of 4 senior counsel and 5 junior counsel. 16. The parties are granted leave to approach this court on the same papers duly supplemented for an order varying or amplifying the provisions of this order pertaining to the notice and the costs associated with the notice in the event that this is considered necessary by any party. The entire court order, with the exception of paragraph 8 thereof, is granted by unanimous decision of this court. Paragraph 8 is granted by a majority of 2 against 1 dissension. The reason for dissent and the extent of such dissent are set out in a minority judgment of Windell J, which accompanies the written judgment for perusal of the interested parties. I hand down the judgment. The court adjourns.
Okay, you've got them. Provide you of the prize. Can I also write on the message? Can you give you a card? Do you want my turn? Do you want to drink that? And then I'm supposed to. Fantastic. Thank you so much.
The overall is the gold one.
Which one do you want?
The iPad, please. And the E. Thank you so much. No, the other one. Thank you so much.
Are you coming to this court of
Saving us a lot of time.
Thank you very much for your help.
Thank you.